So, my presentation will be in English, and in this presentation I will focus on a few popular expectations in relationship to judicial function. And popular here has two meanings. One is that they are widespread, and other is that their origin allegedly lies in people. So, main expectation is related to the concept of sovereignty, as articulated in positivistic light in modernity. The expectation is as follows: judges shall not be sovereigns. In an uttermost sense, sovereignty belongs not to them, and we all know where the ultimate source of sovereignty is. It is in people, and it was already said in this hall. As article of Lithuanian Constitution declares, sovereignty shall belong to the nation. Accordingly, sovereignty shall not belong to judiciary as such. Other popular metaphors in this context are: Parliament is only the voice of the people when it adopts law, and judge is only the mouth of this voice when he or she applies this adopted law. Thus, it is also expected that judges will not participate in politics and law creation, as that is not in their powers. This positivistic paradigm has been questioned a lot of times in modern legal thought, and there are many possible lines of critique there. But I would like to draw your attention to the ideas of contemporary English scholar Martin Laughlin, and at a lesser level those of Carl Schmitt. First of all, while considering the concept of sovereignty, Laughlin points that sovereignty has been given such a variety of ambiguous and confused meanings that many have suggested, in the interest of precision and rigor, that concept should be altogether abandoned. This statement, in a very short form, outlines the modern condition in relationship to sovereignty. However, Laughlin himself provides with a clear and interesting conception of sovereignty, which he calls a relational concept of sovereignty. And he states that sovereign authority does not rest in particular locus, as people or the rulers. It is a product of relation or interaction between the people and the state or institutional framework. So sovereignty in this perspective is like a flame which needs a match and a box to get it. The problem is that people as such cannot produce or have sovereignty. Relying on Hobbes, Laughlin alleges that people alone are just multitude. They need governing bodies in order to transform into the political multitude people. In some sense, this interaction actually produces people as political unity, and afterwards sovereignty. So now some ideas about judicial function could be formulated in derivation from this conception. First of all, the thesis that courts shall abstain from the political participation based on positivist separation of law and politics becomes dubious. Laughlin in this context advocates for two ideas. The idea that the separation of law and politics must be left aside, and that the nexus between law and politics is very clear in the domain of public law. For Laughlin, public law, being centered around constitutional law, is practice which is an activity that is neither fixed nor finished. And the meaning function and mode of application of constitutional rules is in reality governed by the practices of politics. So public law is only the instrument of never-ending state building and governing of the activity of governing. It cannot somehow leave the hands of the state builders and rise above them as some ruling law. In fact, it is not really created by people, but essentially by the political legal elites of the state. The examples for all that are actually very nearby. For example, was Lithuanian constitution as text created by the people of Lithuania? Of course not. Those who really created this text, as a matter of fact, belong to the political, legal, or academic elite of those times. Recently, actually, in Vilnius University, there was the conference held devoted to the 20 years of the contemporary Lithuanian constitution, and therein legal scholars, former judges, and so on, shared their experiences about how this document was created, disclosed many interesting facts about the so-called kitchen of this process. This event in itself was also the evidence of one very simple fact, that Lithuanian constitution was created by the small group or groups of professional lawyers, politicians, some academic or even famous persons as writers, and clear political, in a broad sense, elite of those times. The results of this process then were presented for people for their approval in referendum. And as Schmidt wrote about the referendum as early as before the Second World War, in this case, people can only, in the case of referendum, people can only respond yes or no. They cannot advise, deliberate, or discuss. They cannot govern or administer. They also cannot set norms, but can only sanction norms by consenting to a draft set of norms laid before them. Above all, they also cannot pose a question, but can only answer with yes or no to a question placed before them. It may be, how to say, questionable, this approach, but still, I think that the matter of people's choice, in itself it shows that the matter of people's choice is usually delimited by what is produced by the political elite. This understanding very much undermines the positivist legal politics separation. Even the highest law, constitutional law, never slips the hands of those who govern us in a broad sense, including the judiciary. And activism of constitutional courts proves that very well. By this activism, courts expose themselves as a part of a political elite participating in a never-ending state building. And if you follow the logic of Laughlin, there is nothing very negative in that, actually. As he states in the other place, constitutional law is not handed down from above, but exists as a part of self-regulatory processes of an autonomous political realm. But we can employ those ideas in a broader perspective. It is not only that originary source of sovereignty is the relationship between rulers and ruled. The quality of this relationship actually matters a lot. In some sense, the state is sovereign as much as this relationship is healthy. And therefore, we should not underestimate the importance of all the data about how some institutions are valued in the state. And we already know, it was stated here, how judicial profession is valued in our country. These are very important indicators, as they, in many respects, show how sovereign the state is. Now, Laughlin accurately relates his ideas to those of Hannah Arendt, who alleges that political power is a product of the world-building capacity of humans. It comes into being only if and when men join themselves together for the purpose of action, and it will disappear when they disperse and desert one another. Or in other case, she states that only material factor required in the generation of political power is the living together of the people. But in courts, this world-building of humans, or living together of people, continues. Judiciary, as the part of government in a broad sense, is probably in most close relationship with people, especially as individual human beings in their specific problems. Accordingly, judges have to be in some broad sense sensitive while adjudicating, because they also importantly participate in the overall origination of sovereignty in the state. But what means for the judge to be sensitive in such a context and also to be one of the sources of sovereignty? Of course, it is easy to refer here to for example, ideas of American realism and Carl Levelin and situation sense, or just we may state in rather naive, naturalistic manner that for the judge, justice has to be the priority, not the positivistic, neutral legality. This latter principle, I think, is very prone to abuse. Judges, of course, have to respect law. In other places, actually, I advocate for the ethics of restrained adjudication as the opposite to the so-called judicial activism. But that is exactly ethics of adjudication. It is the matter of the realm of ethics as related to law. So what are the facets of this ethics? I think that one of the main facets in modernity is the one recognized by H.L.A. Hart himself, that the ultimate basis for preferring the positivist thesis, which insists on a clear differentiation of law and morals, is itself a moral one. Thus, positive law is not some matter lingering in some kind of ethical vacuum. Positive law itself is positioned in the realm of ethics, especially by this ethical notion that we have to live our lives under positive law. Therefore, ethics of adjudication should be that of restrained adjudication. However, through this kind of adjudications, judges shall never forget that the foundation of the being restrained is ethical. And all this puts judges as a part of state governmental structure in a delicate position. But it is better that when they understand and accept it instead of acting as though everything is positivistically or naively realistically, in both cases nihilistically simple. And finally, why not to transpose the relational concept of sovereignty to law itself? Maybe law also is a matter and product of the same relation between rulers and ruled. We should consider law not as a product of only people or only government, as some particular material loci of origination, but as a matter and product of relation between people and their government. That would in itself add to the critique of the phenomenon of materialization of law. It would show that law is not some kind of precious diamond changing the hands of state, people, legislator, courts. The whole material property kind metaphoric in relation to law and sovereignty should be set aside, and including, I think, what is stated in our constitution. Because if we pretend that this metaphoric is correct, in some sense, then we may start also pretending that some kind of monopoly game goes on in relationship to law or sovereignty, and that law may be colonized by, for example, lawyers, as it might have happened with the constitutional law in the 20th century. But this might be the whole wrong metaphoric or poetic. Law maybe finds its source not in something material, thus itself being material, but it finds its source in relation, thus itself being sole matter of relation. And I think this idea once again negates the positivist paradigm in relation to law and in relation to the judicial function. Judges are neither the mouth of law, not owning law, nor they are creative source of law, so owning law. Judges, being the part of the overall institutional governmental structure, participate in the interaction of the latter with the people, and only this way law, as law from the capital L or right, may come into being. As already stated, all that necessitates the delicate balancing between positive law as it is and ethics or justice, wherein the ethics of people living under positive law also finds its place. Thank you.